We typically identify two types of defenses that are used to argue why a person should not be held responsible for a criminal charge. One of these defenses is known as a factual defense, or sometimes called the alibi defense. With an alibi defense, the person is arguing that they didn't do it. They were somewhere else. It wasn't me. They're challenging the accusations from a factual basis. The facts, as the prosecutor alleges, are untrue. The other type of defense is known as a legal defense, and these come in two forms: justifications and excuses. Now, these are categories of legal defenses, not specific defenses in and of themselves. There are specific defenses that you could argue under the justifications label, and there are specific defenses under the excuses label. The one thing they have in common is that the argument is not over the action. The defendant admits to committing the act, but is instead arguing something else. With justifications, the defendant is arguing that the act in question was necessary to avoid some greater harm or evil. With excuses, the defendant is arguing that some circumstance exists that should negate his or her culpability under the law. So if we go into the Texas Penal Code, we're going to look at chapters 8 and 9, justifications and excuses. In chapter 8, what we would categorize as excuses are labeled as general defenses, and chapter 9 is justifications. We're going to look at justifications first. So there's some general provisions, and the way these work as far as legal defenses is if they are acts committed by the letter of the law, meaning there's no controversy involved, then justifications serve to negate criminal charges in the first place. So, for example, if we looked at self-defense, there is a statute here that qualifies us for what is self-defense, when you can use force to defend property, persons, when you can use deadly force to protect property or persons. And if you follow that law exactly, and the self-defense that you are alleging is factually accurate according to what the law allows, then the police aren't going to arrest you for a crime. The prosecutor's not going to charge you with a crime. Where people end up arguing self-defense in court is when it doesn't match what the law says. So, for example, this is a circumstance in which self-defense is not justifiable. Okay, so let's suppose that Bob starts a fight with Ray. Bob is beating up Ray. Ray pulls out a gun to defend himself, so Bob pulls out his gun and shoots Ray, and then claims that he was using self-defense when he shot Ray because Ray pulled a gun. And this wouldn't qualify as self-defense because Bob started the whole confrontation. And so we would arrest Bob, he would be charged with murder, and then he would go into court and argue that it was self-defense. So let's take that same example and just stop it a little bit short. Bob starts a fight with Ray, he's beating Ray up, Ray pulls out a gun and shoots Bob. That's closer to what self-defense would look like. Ray probably wouldn't even be charged with a crime. The police would resolve the case after an investigation and no charges would be filed. So let's take a look at another justification. Here's section 9.22, necessity. And this is the whole argument of justifiable in general. There's just going to be some other categories of or circumstances of necessity that don't fit into the self-defense category. So if you look at necessity, the actor reasonably believes the conduct is immediately necessary to avoid imminent harm. Focus on imminent. It has to be immediate. It can't be future harm. It can't be conceivable harm. It has to be imminent harm. And the reasonable belief that if I commit the action, whatever action we're talking about that's against the law, I have to commit that action to prevent that imminent harm. The desirability and urgency of avoiding the harm clearly outweigh the conduct that you committed. So this is typically looked at as a lesser of two evils option. You cannot sacrifice one life to save another life. You can't sacrifice one life to save three lives. So you can't use the necessity defense that I had to murder my hiking partner because I was going to starve to death. That's not outweighing the result or the conceivable harm that might come. So we could come up with an example like maybe if you were hiking in the woods and were stranded and lost and the temperature was dropping and it started snowing and you were in dire need of shelter, that you could argue necessity against a charge of burglary if you broke into someone else's home or cabin, seemingly unoccupied, to protect yourself from dying as an exposure of the elements. Maybe that would be necessity. Maybe you could argue it's necessity against a charge of indecent exposure if you removed all your clothes after they caught on fire and you exposed yourself, but it was necessary to prevent a greater harm than the action that you committed. So there's one other thing I want to show you. There's another defense that's typically considered justification. It's not found in Chapter 9, but we can go all the way down to Chapter 22, which is our assaultive chapters under Title 5. And there is a consent as a defense to assaultive conduct. So the victim's effective consent or the actor's reasonable belief that the victim consented to the actor's conduct is a defense to prosecution under 2201, assault, if the conduct did not threaten serious bodily injury, and if the victim knew the conduct was a risk of his occupation, his medical treatment, or scientific experiment conducted by recognized methods. So as an example, sports participants get injured all the time. People get hit, we get bloody noses, a boxer gets a black eye, whatever it may be. But they consent to that as a part of their participation. So we don't see athletes getting charged with assault or for harming other people because of this consent defense. So these all fit in the justification category. So if we go back up to Chapter 8 and look at the general defenses, these are what we typically look at as excuses. They aren't necessary, but they might help and explain some of the need to reduce or negate completely the defendant's culpability. So insanity, intoxication, duress, entrapment. The insanity defense is more complicated than I can get into with a single video. Age affecting criminal responsibility. Entrapment is essentially a defense in which a defendant uses law enforcement's unnecessary persuasion in which a suspect commits an offense that without the government agent's actions, the person was not likely to commit in the first place. So an example of entrapment would be if a undercover officer approached you about buying your recently deceased family member's pain medication. Like they frame it as they need the pain medication. Their mom's dying. She's in pain. She needs medication. She can't afford it. Can I buy yours? If you like acquiesce after one time, that's not entrapment. That's just kind of an undercover operation that might be pretty standard. But let's say that you say, no, I'm not selling the medication. And they come back the next day. No, I'm not selling the medication. And over and over and over and over, they lay this guilt trip on you about how their mom is in so much pain and you could ease their suffering. And it's just a constant attempt to get you to sell the medication. You sell the medication, then they arrest you. You could probably argue entrapment. If you take away the officer's actions, even though we don't know it's an officer, if you take away his actions, our defendant probably wasn't going to sell anybody the medication. So that's kind of what entrapment looks like. Intoxication as a defense, you might be able to argue involuntary intoxication, if that's included in here. Voluntary intoxication does not constitute a defense to the commission of a crime. So when we talk about intoxication as a defense, we are referring to involuntary intoxication, in which the defendant did not intentionally intoxicate him or herself. Duress is another one, 805. You might be threatened if you don't do something. So you might be able to argue duress in those circumstances. But that's just a handful of them. So the main point I want to make about justifications and excuses is that they don't involve necessarily always clear-cut real-world examples. Sometimes things are open to interpretation, or it's an investigator's opinion that it wasn't justified. And so sometimes these do end up in court, even though they seem relatively clear-cut. And then ultimately they're left for a jury to decide. So this is just a quick rundown of legal defenses. Again, chapters 8 and 9 of the Texas Penal Code have more information about what Texas considers to be defenses. But this is just an introduction.